May please, your lordship.
Yes.
My lord, I mentioned item number 28 of the supplementary list. My lord, this is a fixed matter, but I have to take for time on 19th matter may be taken up. I have taken the consent. I informed senior counsel.
19th.
19th.
19th may not be possible.
But he has some difficulty, he says, after that.
19th, and on the prayer of the learned counsel for the respondents, matter stands adjourned and be listed on 19th.
No problem.
May I please, your lord. Okay, let me mention item number 23, lord. I have taken the consent.
20,
23. It is also fixed with 22. I have taken the consent. 22 and 23.
2015 method.
Yes, today there is some percentage with.
Wait for it.
22 and
Huh?
don't have any objection for it.
So,
If lordship has any.
no, I am not granting. Yes, next, we'll see.
May the lordship, the son of Dr. 24 lord. 5
20?
minutes, 4 lord. 5 minutes after any date of tomorrow.
Any interim order?
Yes, lord. Tomorrow.
It's not the way. Tomorrow, we are not ready to hear your case only. Wait for your thought. We'll see.
For convicting of the contempt petition, my contempt petition on 18th next month or any other.
You go to the green bench.
Right.
I'm taking the second bench only for you.
May please, your lordship, with due consent of other side, your lordship, I pick to mention item number 9.
Okay, any consensus that it will be remanded to there was a proposal
Lordship,
to be remanded to the Board of Revenue. There was a submission made that it may be transferred to the, you said it is expertise order, or you are not aware of anything?
Lord, I am aware of it. There was the expertise order.
That expertise order, there was a, this court observed that whether this matter after setting aside can be remanded back for fresh hearing in presence of the petition.
but sometime maybe, my senior is, due to Roja is feeling not well here.
You are for the petitioner.
I am for the respondent 6 to 11, your lord. He's for the petition.
We'll admit this, we'll hear whenever time permits.
It is not possible. If your
We'll
lordship
hear it, we'll
may-
hear it. This needs a hearing. It's a whether royalty or non-royalty. There is a determined status quo is there. You are in possession. We'll hear it after 10 years.
After?
After 10 years. We'll hear it. Admit. Issue rule. Records are there. See. Records are there. Records are there. Actually,
I am informing my senior lordship. If he, then he will.
admit for hearing. Issue rule. No fresh notice be issued as the parties are duly represented. Place this matter for hearing in its own turn. Interim order passed earlier shall continue until further notice. Yes.
May please, your lord. I am taking apology, lord. Item number 20, lord. 20, lordship. Our officers know file. I have tried to
Now
construct.
tell us anything survives in this petition to be adjudicated.
So that notice of 2015, that notification.
That notification is
That
there.
notification,
Thereafter, there were developments.
What?
There were subsequent enhancement of rate and all.
That we are not doubted. That there is no absolutely no problem. And then
You have, in fact, from the day one, you have been given the absolute relief.
no. What I am saying, that's there, but interim was given. To be on the day
Interim,
one.
by way of the interim, you got the absolute relief.
No, that's why it should be discussed.
Today, what will you decide today? Except the legal issue.
And there is one.
Except the legal issue.
No, the legal issue has been decided by the Supreme Court. 2019 Supreme Court has decided.
Hmm.
That there is no question of the government to categorize.
Hmm.
It is the plantation department, plantation industry who categorize. Your lordship has asked one question to my learned friend.
Hmm.
That was very pertinent. I also asked, then my learned friend said that your lordship has asked a query. Who categorized? That's what the precise query
Ah.
that was put for.
Sir, this is academic agenda.
No, no, not.
It has lost its force.
No, it's not. Then your notification has to be set aside. That
Yes, you have your
notification
instruction.
2015 has to be set aside.
Lordship, I pray Lordship, may die, allow us to construct the file Lordship on the court second file. Lordship.
No, file, it's a legal
Otherwise,
issue.
Lordship, regarding, I have no knowledge regarding FZ also, Lordship, in the status. So, Lordship may only allow us to reconstruct the file, Lordship, then I can, Lordship.
Reconstruction is not a problem, we will allow you.
Okay.
But issue is this,
Okay.
a proposal,
Okay.
what is called, Mr. Das, to include some person in the schedule of the minimum wages.
No, no, no. That's I pay.
Yeah.
That's there is a notification issued by the state government in 2015, where they said, as per section 27,
Ah.
they can add to the schedule.
Hmm.
But in the notification, the government has categorized
Hmm.
the workers,
Ah.
workers as semi-skilled.
Ah.
So whether that is
So who will
permissible
do,
or
who
not.
will do the, because it's question of schedule,
Categorization
who will
of-
categorize them?
So, Lordship may give some time, I will obtain instruction regarding, and my Lord may allow us to.
See, either way, state will have a ramification on this.
Lord,
If we decide on the,
Lord.
and other issue is whether anything survives to be decided
Lord,
here.
Lord.
No,
In factual, forget about the legal issue.
Lord.
They have done it, that has lost its force.
no, my lord, I will tell you.
Ah.
See, under the minimum wages, he will have
Hmm.
time. Under the minimum wages, there are two sections.
Hmm.
Section 3 and section 5.
Hmm.
Where minimum wages are being fixed under section 3.
Hmm.
Section 5 is a procedure that has been laid down
Hmm.
under minimum wages. There is a committee which they
Yes, you
form.
understand?
That committee will form. They will
Because
do the
you
report.
need a factual determination.
Yes, now from time, this was since 1952. There was a Setia committee, 1952. Time to time, there is a enhancement of the wages. Minimum wages act has been enhanced till 2023. Now, there is absolutely no doubt that enhancement of the wages can be. But what has been done,
Categorization.
that has been done in 2015.
That was what,
Ninth-
that the question what we asked on the last.
This is a
occasion.
legal
This is
issue.
the, you will have to answer.
My lord, nine.
Whether we can categorize or not.
Okay.
Lord.
Skill,
It's a
semi-skill.
skill part.
Suppose these people were unskilled workers.
Lord.
Now, by way of the notification, they are declared to be semi-skilled or
Semi-
semi-skilled. Now, where
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 they
is
got
the power?
Lordship.
And if you have the power, how is this to be
Lordship,
done?
Lordship,
That is the issues to be
Lord.
answered. I think
That's
this is,
There's
Yes.
a very short
Lordship.
issue.
and for that you do not need anything except the act and the rules. Because it's the question of your power.
Lord.
That's all.
I tried
Okay,
to get.
Mr. K. Gogoi, learned counsel representing the state, prays for a little accommodation. As he has misplaced his brief.
Because in the office, today they.
We'll say that only.
Lordship,
Please,
Lordship.
please. Full stop. Mr. Das, you can give the copy to him.
Lordship.
Only the writ petition, no affidavit, I think. Affidavit has been
Affidavit
filed.
has
Give
been
a
filed.
copy.
Lordship.
Full stop. Prayer stands allowed. Please this matter on.
Lordship, after 10 days, I will come with a definite instruction.
What instruction you need? You need to argue on law.
That's
You
all.
know, that, if I can argue on the law, then next week also.
Only 1 second. Well, let it be on next Tuesday, coming Tuesday.
Coming Tuesday possible? 19th. 19th.
Lordship, Lord.
19th. In the meantime, copy of the writ petition along with the affidavit filed by state be furnished to Mr. Gogoi by the law. Or we need not record it, you give it to.
Lordship, Lord.
Okay, will not record.
Only law point, Lordship, I have to address, Lord.
That's all.
Lordship.
Your power.
I
Lordship,
will
Two
not-
categories.
Today I will not cite a judgment. There is judgment which is settled by the Supreme Court.
Give us,
Oh,
give us.
yes, I'll give it.
Okay.
It is settled. But
Keep a copy in the file.
I was, that's why I was, when I didn't go to the judgment, subsequently I have gone. I thought myself that who categorized? Suppose an employee working for 5 years in a garden. So after 5 years, he or she get the experience of plucking.
So you may be a
pruning.
skill, semi-skill,
No,
depending
that's-
upon the factual determination.
Now the Supreme Court said that cannot be done.
Hmm.
I thought myself that will, kindly see 14, kindly
Yes.
see para 14. 2019, 15, 774.
Paragraph
Right.
14.
14, see paragraph 14, man. Paragraph 14.
Yes.
There is no power vested in the government by the act, the minimum wages act, to make alteration to the terms of the contract, because there is a memorandum of settlement
Mm.
with the employer and employee. The act only confers jurisdiction in government to fix,
Mm.
revise the minimum rate of notwithstanding the contract. That's only the government can do. Now see 14.1. The notification dated 21/10/2020 postulates that unskilled employees having 5 years experience would be deemed categorized as semi-skill A, that after 3 years of experience semi-skill A, the employees would be deemed categorized as semi-skill B, that after 3 years of experience skill A, employees would be deemed categorized as skill B. Such categorization or classification by deemed workmen in one category to belong to another category is in direct contravention of the contract between the employer and employee and is beyond the jurisdiction of the government. So government doesn't have any role.
We'll see
On 19 lots.
on 19th.
Lot.
Keep this in the.
Kabla Julu.
On 19th.
Lot. Kabla.
Before a lottery opens the file, it's a very bad case, my lord. The allegation level
It is very bad case.
very bad case. My lord, only my lord, only one submission I'll make. The lordship pleases, my lord. I'll leave it to lordship. My lord, page 14 is the FIR, and my lord, the position of the doctor and the page 25 and 20. 3 page your lordship is in the chamber, my lord.
Paragraph.
My
I have
lord,
seen.
page 25 and 28. 26, the cross part. I understand my limitation. My lord.
Page 27.
Page 26, my lord, the cross part. My lord. Fifth line, my lord. The accused while came to my tea stall engaged in talk with my wife, which I do not like. I had often rebuked my
We
wife,
have seen that, but
Yes, ma'am.
what about the child?
child, my lord, and the
Oh.
doctor's report.
Doctors, I'll clarify.
Doctors,
No, after
do you-
2 days.
you
I'm not arguing, my lord. I'm not
Dismiss.
arguing, my lord. I just
Dismiss.
I'm just pointing out, my lord.
dismissed,
After 2 days, that is.
dismissed,
Rejected. Rejected.
rejected. Sorry, rejected. Now I'm in a bench force, so there is no question of rejection. It's a dismissal. Rejected. Yes,
Classification lordship has called for the up-to-date report, my lord.
Yes, my lord, after that report has come, my lord.
Mm.
The earlier two was PW 1 and 2 examined, last, the latest part, my lord, PW 3 also, my lord, examined.
what is the status now?
My lord, out of 13, now only 3.
Three.
And that is around 2 years.
It is-
And-
My lord, actually,
And,
What is the similar order passed earlier?
first earlier, my lord,
but one.
Now
thing is,
this
my lord,
is created
One,
a
why one is matlab, how get anticipatory bill.
This is-
That is the main, he is the main matter.
He's the main.
my lord, the order for 2 persons granted bail by the
He is since matlab 9/4/22.
Now, how many witnesses by now?
He only,
He only.
Three. When was the last?
Last on
it was on 12/1/2024,
12
12 one
2024,
out of 13.
out of 13.
out of 13.
Okay.
Last order on 6/3, he was on again leave. That is,
Where do we get that latest update?
matlab in the LCM matlab.
This is the
Okay,
file.
we'll see. We'll see.
Yes, sir. Problem.
In this first, my lord, we are directed to take step respondent number 7 by Dusty Service.
Hmm.
We have already taken the step, my.
You have already taken the steps.
Yes, my lord. To Dusty, my lord, we filed the affidavit. of
File the affidavit.
Yes, ma'am.
Respondent number,
Respondent number 7, my. Dusty kindly come to running page, my lord, 45. 48.
and who is appearing for whom? Tell us.
Lordship, I am for 1, 2, 3 for fishery department.
And
I'm for the respondent number 6.
missing autonomous. 4 and 5. Nobody for,
I am 7.
you are 7. So parties are duly represented, all. Okay,
Yes, sir.
petitioner has taken justice service,
Even if you take for a little bit.
justice service. Full stop. All the parties are duly represented, full stop. Accordingly, this matter is ready as regards service. Any affidavit?
Lordship, will file it is demarcation matter, Lordship, the process has been started for demarcation of the fishery, my lord.
Hmm.
I'll file affidavit is required. Otherwise, I have instruction, but main issue is the demarcation of the boundary regarding the missing Thomas Council and the government fishery. The time waiting to
Okay.
file.
When
My lord, may kindly take this matter along with WPC number 295
is
2024.
submitted that analogous matter being WPC
295 2024.
295 2024
This today also you have number 4.
No, I will
Is-
inform this. Honorable Court.
is pending for adjudication. Full stop. Learned counsel for the party submits that this matter also be tagged along with the said application. Priya
Okay,
Rizal,
your pleasure.
Place this matter on
After
after 2 weeks, along with WPC
295
2925
295
295 of
2024.
2024. In the meantime, parties may exchange their pleadings.
Sir, there is an interim.
Interim order pass earlier shall continue till the next date of listing.
Our name is. It's in.
Registry to reflect name of all the learned councils representing the parties.
Give your blessing.
We have not recorded anybody's name.
Oblige, Ballot.
We do not want to waste time, paper, ink, recording council's name until and unless it is very necessary for you for other purposes. Yes.
The last order, my lord, 29.
Yes, my lord, I was directed to file an affidavit, my lord. Our affidavit is ready, my lord. We have sent it due to examination, my lord. Examination over Friday, my lord. That's a fast track. In the meantime, we'll file it.
Okay. On
Next week.
on the prayer of the.
That's the Tuesday.
Okay, you return it back to. It's difficult, it's an anxiety for them.
Right.
The Mr. T.C. Sutia Learned Council, should we release it from Parthad?
No, my lord.
Let it be there. Let
Huh?
it be there, well, because he had made a serious allegation
okay.
against
Okay.
me, my lord.
Don't fight, huh?
Right.
Don't fight.
So Friday, my lord, Friday I will do
No,
it.
no, Friday. No, Friday no. No, I said, should I, because I'm taking a different bench.
Let it be part of it.
No, my lord, no problem at all. My lord, why release, my lord, lordship has already heard this matter, my
Okay,
lord.
Yes.
okay.
Friday, my lord, I will do it.
Mr.
Yes.
T.C.
Yes.
Sutia Learned Council submits that he is in position of the record and would be is filing an affidavit in opposition by Friday next. Friday next?
This issue, my lord, matter may be released on 19.
I'll call, we will require time to reply.
If by Friday,
Uh,
accordingly, list this matter.
Next week, any date, but
19, my lord.
18th of
18 won't be one day, then it be 19th, my lord, because
19,
19.
too many matters are fixed for that.
My lord, his certificate is to be required to compare.
No, yes, we'll require it, he will keep it, he will
Yes,
keep it.
he will have to produce.
Yes, yes,
okay. When, 18th?
No, it's
No, 19th is not
19th.
possible.
20.
20. 20. Full stop in 2020, full stop. The original certificate produced by Mr. N.J. Datta and kept in the safe custody of the post-mortem of this court is returned back to Mr. N.J. Datta. Full
And
stop.
that will be
Same
put-
be kept ready for, same be kept ready on the next day.
Next. I'm applied.
Obliged.
He return it back.
That they have returned. Final report was submitted supplemental notice, court issued the notice to informal law. He appeared and exited prison to 5.
You object there? Because notice has been issued to you,
Yeah, he appeared once.
you have appeared, so you file an objection. Full stop.
But only thing is that, my lord, petitioner entitled some explanation. Liberty may be given to the petitioner, we have to deputy commissioner.
Okay.
Deputy commissioner will proceed.
Whether he is died or killed, it is not clear.
Commissioner will call for report from the concerned.
Just listen to the order. Pursuant to this court's order dated 4/3/2024, Mr. Goswami Learned Counsel on instruction has submitted that final report has been placed before the learned jurisdictional judicial magistrate, and final report being being FR number 33/2023 dated 28/2/2023 in connection with filed in connection with Lakshmipur PS case number 337/17 has been placed before the jurisdictional judicial magistrate, and the learned magistrate has in the meantime have issued notice to the informant on 25/7/2023 for his appearance, and the matter is again fixed and thereafter matter is now fixed on 2/5/2024. Full stop. It is also reported that the informant has already appeared before the jurisdictional magistrate on 6/3/2024. Full stop. In view of the aforesaid, the writ petition stands closed. The petitioner will be at liberty shall always be at liberty to raise his objection before the learned judicial magistrate, and the learned judicial magistrate act in as per law in the event such objection is filed. Full stop. So far relating to the payment of ex gratia, liberty is also granted to the petitioner to approach appropriate authorities if he is entitled for such ex gratia in terms of the extant norms.
Instruction kept.
Okay, the report dated 7th March 2024 submitted by Superintendent of Police Goalpara is kept on record and marked as document X.
My lord, Senate Counsel Mr. B. Gogoi is appearing in this matter. My lord, he is arguing in point number 4 matter.
I may just give the brief, my lord.
Don't make it part hard. We have already 3 part hard.
Let me see that the issue, my lord, the issue.
No, I have seen. Issue is that earlier writ petition, one set says that nothing doing, it is allowed. So far relating to others, certain facts were assertions were required, that was remanded back. Now, according to you, in terms of the earlier judgment of the apex court, which says that you cannot have this interest and all,
If no tax is payable.
not payable, and it should be determined from the date when it was given, and it was also determined in the earlier writ proceeding by the division bench. However, they passed this order
Look, they went beyond the.
beyond the order of the
And
Supreme Court.
subsequently, my lord, subsequent development, but the SLP has been dismissed.
Hmm.
By the apex court. Against the judgment.
By the division bench.
Being made.
Ah.
And the apex court only said, my lord, let me just.
Hmm.
Page 55,
Page 55.
a relevant part, my lord, that in the last paragraph.
Hmm.
55.
Hmm.
However, we clarify that in terms of the judgment dated so and so of the Supreme Court in so and so. Indian Corporation versus so and so. The respondent Indian Corporation Limited will be liable to pay sales tax on the differential amount along with interest as per statute.
22.
So, you know, the differential amount I paid,
Hmm.
not interest is to pay as per statute.
Hmm.
The judgment of this honorable court has been upheld by this SLP. This honorable court has held that interest is not payable. Now, how the interest can be levied by them?
So we'll hear that, we'll finish it up,
Yes, Mr. B. Gogoi.
we'll dictate it today itself.
You know, this letter, the document, the order sheet, it has to go down 7 benches.
Now, hope that this will be the last bench.
Management got it as for third and further year. Otherwise,
we'll hear it, decide it
No, no.
today itself.
not started. Today itself, I'm going to.
Huh?
Today itself, we'll also taking that.
We'll do it today itself, isn't it?
My lord, he will come, my lord.
Okay, let him come. Short, narrow campus,
Zero compulsion.
very narrow campus.
And the assessing authority
Hmm.
is saying that, my lord, they have misleaded the court, high court and all. How, my lord, he can say, and re-examine the matter of 22 as if money.
We'll have to see what was the determination made by the Supreme Court and how it was interpreted by the division bench and whether they have acted in terms of that determination made, that's all.
Division bench SLP has been dismissed.
Huh.
So division bench judgment made.
Yes, final.
Now the Supreme Court only says interest as per statute. Now as per statute.
That has been interpreted when it
This
used
all
to
the
be
court
done
will
by
do.
the division
So
bench.
that has attained finality.
Yes. Now only you'll have to determine whether in that calculation is in terms of this.
No, my lord, this on the court said,
Huh,
if there is no tax demand in the demand notice, then no interest.
no interest.
Now there is no dispute, there is no tax demand,
So therefore, no interest.
no
This is the
interest.
case.
They are saying that calculating it not from the back. How the back can be calculated, my lord?
Let Mr. Gogoi respond to it.
My lord.
Otherwise, we have a little bit understood your case. Now let us see
Your
what
lord,
is
you have gone through the brief, entire brief, so.
some little homework. Yes. After some
Today,
time.
I hope that today it will take it up.
Yes, we'll take it.
Fine.
Hello, please, my lord.
May I please,
Yes.
Lordship, after the filing, Lordship may peruse the judgment pursuant to which we had filed it.
No, first tell us what is your prayer in this writ petition.
Lordship, what had happened,
Hmm.
we had sought for the cadastral map. After that,
Hmm.
there are subsequent developments when we had filed a subsequent case. That's what I want to project to your Lordship. What had happened is that
Hmm.
as per the earlier order, the
Hmm.
DC was the circle officer was supposed to conduct a report and conduct the inquiry.
Hmm.
Now, what he did is that we have 130 bighas of land.
Hmm.
The report that the circle officer ought to have been made was pertaining to one particular plot of land. But according to our information, he went and filed a report saying that all are non-K land. Pursuant to that, an eviction order was the order was issued, and all our it was evicted. It was earmarked, and we have been dispossessed. Then we approached the honorable court by WPC number 2440/23.
Mm.
In that, wherein we are granted interim protection at the initial stage, saying that we will be allowed to operate the factory. Thereafter, we filed a subsequent IA, wherein we sought for clarification because some part of it.
Which writ petition? Earlier writ petition?
No, this writ petition. After this writ petition, earlier writ petition was there. Then there's an order in that writ petition.
Hmm.
After the order in the writ petition, we participated in the circle office hearing and everything.
Hmm.
Now, when this hearing was going on, the circle officer passed an order.
Hmm.
That order is still not on record, and we have not received it.
Hmm.
What we have understood from that order is that instead of confining to the particular area, instead of confining with a particular area, the circle officer went beyond that area and he went and gave a report to some other part of the petitioner's land.
Hmm.
Now, after that, then eviction notice was issued and there was a eviction there and we are sealed. Then we approached the honorable court by virtue of 2440/23, wherein the honorable court granted us an interim order.
Hmm.
And the by virtue of the interim order, there was some clarification sought for.
Hmm.
And in that IA, the honorable court asked for further direction. If Lordship allows me to place that order,
Hmm.
which will, in both the cases, needs to be heard together because the order passed in WPC 2440/23 pertains to this land as well. So, if Lordship,
Now, what is the challenge in this writ petition?
we were not provided with a cadastral map. So this cadastral map is ordered.
Our only prayer is,
Hmm.
matters should be heard along with the other. Because these
Then
are all
it's-
interconnected.
Well, I have an objection, my,
Yes, tell us what is your objection.
yes, sir. My humble submission before your lordship, what is the case about this case, my lord? For the other case is something different. There is a, my lord, my lord, eviction took place. They come to this honorable court, my lord, where this honorable court has said that what that in non-cadastral land, you can carry out, but cadastral land, you have to stay the proceeding, my lord. And there is an order, my lord, Honorable Justice S. Surana passed order, my lord.
Don't take names, Mr.
Sorry, but sorry. One thing is that, my lord, your lordship, in this case, I am submitting, my lord.
Hmm.
This is a case,
Here prayer is to give a copy of cadastral map of
yes,
so and so village to the petitioner
yes, my lord.
and to measure disputed plots of land through the Assam Land Survey Department. Okay. I could understand for the reason that they say that we have wrongly been evicted. If I am not mistaken. They say that we are wrongly been evicted. If
Not to
we
be evicted.
sought to be evicted or evicted, this, if maps are given, we can establish our right.
Yes.
Is it not a case?
No, my,
No, in this case.
yes, my, no, my lord. Your lordship kindly go to the prayer portion.
That is why.
Yes, my lord. And may I read my lord prayer?
Huh.
Yes, my lord.
Here is an eviction and proposed eviction.
No, my lord. Your lordship kindly, it is therefore, your lordship say admit this application,
I am at page 30.
page 29, my lord.
Page 30, 29, don't
May I
read.
read,
Go
my
to
lord?
page 30. Yes, read.
29,
Yes.
particularly circle officer, the copy of cadastral map.
Okay.
Relates Solutori Moja to the petitioner to measure the disputed plot of land to Assam land.
What
and
is this disputed plot of land? Is this disputed plot of land is a subject matter of this petition?
No, my lord, let me allow to
Okay.
submit, my lord.
Okay.
That is the case, my
We have allowed it.
This is the case, my lord,
Hmm.
where they have first time they come before the court. A application has been filed to the circular office, my lord, by the tribal Sangha, my lord, on the basis of my complaint that in the tribal belt and block, some non-tribal people transfer uses possess the plot of land,
Hmm.
my lord. This is the case, my lord.
Hmm.
And that is the my land, my lord.
Hmm.
Then tribal Sangha, my lord, file a complaint.
Hmm.
On the basis of that, my lord, circle ADC also submitted a report.
Hmm.
Then they come to the High Court, my lord.
Hmm.
This honorable court, my lord, the matter has been heard.
Hmm.
It is a very tough to heard the matter because other counsel of the lawyer, I should not mention the name.
Don't go
Not
to
this.
all those, Mr.
This is
Chudhary.
reason
Come
behind-
to the, what is today is required.
Yes, my lord. When
What
I
is
had
required
submitted,
today?
my lord, because reason behind it, my lord. When I submit it, then my
No,
lord.
that will come to the reason later.
Yes, my
Now
lord.
we are on a
Yes, my lord.
capsule. What
Not
is
not
what?
just this set of lawyer,
Yes.
other lawyer, my lord. Then, my lord, this honorable court ultimately
Hmm.
dispose of the matter, my lord,
Hmm.
directing specifically there has been fixed that so and so date you what copy net you give, and thereafter you hear the matter, and without, my lord, quashing the notice of that, my lord.
Hmm.
Not kindly go to the that order, my lord, important, my lord.
Okay, we'll go to that. Then it was that notice of eviction was not set aside.
Not set aside.
Only opportunity of hearing was given. The
And
matter was
yes,
fixed. Then what
earlier-
happened? What
yes,
happened
my lord.
thereafter?
Earlier, they are not asking for cadastral map, my lord. They
No,
are
no,
asking,
it will come to
No,
the. Then
that-
what happened? Facts.
lordship, kindly, that is the important thing, my lord. That is cadastral map. That they are asking only complaint petition and other. They knows they cannot give the cadastral map, my lord.
Hmm.
If the your lordship asks the cadastral map whole of the Guwahati, my lord, it is not possible.
Hmm.
But test map is available. They are producing in other cases, and they produce this test map. So they want ask the cadastral map, my lord.
Okay.
Then, my lord, revenue officer has said,
Hmm.
page 129, no?
Hmm.
129,
Mm.
we cannot serve the cadastral map.
Mm.
It is not possible to serve the cadastral map.
Mm.
All the document has been given. They know cadastral map cannot give it. If you also ask me to ship the Urbosi to the Umananda to
No,
Urbosi, I cannot do it.
don't argue
Yes,
this.
sir.
Argue this. Say that
Yes,
no cadastral map
Yes,
is
sir.
prepared. There is no cadastral map.
Yes, sir.
Don't go to
Cadastral
Ananda and
is available.
Kamakya. Go to
No,
that.
my lord, cadastral map is available. It is in the, my lord, survey office. It is a big map, my lord.
Okay.
Yes, my lord. So, there is-
Cadastral map can
Yes,
be
sir.
given copy of a specific area.
Yes, my lord.
Is that
It can be given statement they produce in other cases.
okay?
Statement they produce, my lord.
Okay.
A statement
Then
is necessary.
then now
What
suppose
happened, my lord? They come to the writ petition dishonorable.
Hmm.
No interim order has been passed, my lord.
okay.
Now, my lord, the matter is that there is many judgment, my lord, that you hear the matter and dispose of within the period. This is the mandate of the first order also.
Hmm.
That was not done. No interim order has been passed. And this matter has been, my lord, stopped for many days, my lord, due to this cadastral man was not served by them, and it is not possible for them, my lord. And secondly, my lord, no stay order, and they are enjoying these things. And there is a specific, my lord, no order for stay of this, my lord, hearing, my lord.
Okay,
Now they want to take that case where the eviction has been stopped for some other purposes, stating that you might made the survey of the land. I don't know survey has been made or not, my lord. Due
okay,
to this, only
Okay.
hearing took place this case, my
okay.
lord.
Forget about the other case. Now
Yes,
let
ma'am.
us come to this case.
Yes, my lord.
Now they say that we need the cadastral map
Yes, my lord.
and two disputed plots and a survey of land survey by department. There is no stay order in this case.
Yes, my lord. And this is the, my lord, map statement they were annexed in the other cases. I am not saying, let them say whether
So
cadastral.
therefore, it is the government who will have to say that
Yes,
this
sir.
is not
And
possible.
first time, my lord, they are not asking for cadastral map, my lord. Second time, then hearing took place, my lord,
Mm.
they asking for cadastral map. For second time, second opportunity, they asking for cadastral map, my lord.
Second opportunity where?
Second, first opportunity, they produce some document, they are not asking for cadastral map. Subsequently, they should know.
In the
they-
hearing process.
Yes, my lord.
What is the stage of hearing?
Stage of hearing is, my lord, due to, my lord, I don't
Now
know.
they say that they have already been evicted pursuant to this court's order,
My lord, they have evicted some part of the land.
not your
Yes,
land.
my lord. My humble submission before your lordship is that, my lord, let the first circle officer decide,
Hmm.
as per direction, first order of this honorable court,
Hmm.
whether they can transfer, uses, possess the land of the Assam tribal belt and
Hmm.
block. Because Article 162
Hmm.
has said
Hmm.
you cannot transfer, uses.
Now
possess.
so as the earlier order.
Yes, my lord. Yes. It's to call, Page 92. 94. Upper the 598, my lord.
Hmm.
My lord, your lordship, kindly come to page 8, my lord, 97, my lord, page 8, correct. Have your lordship got it?
Hmm.
We are the view that such minor discrepancy cannot be reason to interfere with the notice in respect of an inquiry on an allegation that the land under the restriction alienation under Chapter 10 Assam Land and Revenue 1986 had been alienated and transferred in the name of person who are authorized not entitled to hold such land, and further land purchased by the complainant Mansingh Rangpi is also being claimed by the writ petitioner Urbanchal Cement Private Limited to have been purchased by them. The bigger cause of the complainant need to hearing, to have purchased by them. That bigger cause of the complaint need a hearing, but same must be done by following due procedure of law by adequate opportunity to the petitioner. Accordingly, without interfering with three notices, we require the petitioner to appear before the circle of the Sonapur Avenue Circle. Either person through his authorized representative upon the appearance circle officer to provide the petitioner with entire sort of documents sought to be relied upon against them so that unable to form objection.
Now where is
in it.
your application for seeking this cadastral map?
Yes, my lord. 130, my lord.
Huh?
30, my lord. May I read, my lord, whole, my lord? Because some line is available.
100?
113, man.
113, my lord. Twelve 10/2022, they filed an application, my lord. With reference of the author above, we appeared before the owner for filing objection, wherein we have requested the copies of the following document. Cadastral mail duly vetted by the
Now
government.
what is the circle, any order passed by the circle officer?
Yes, my lord.
Where is that?
129.
129, my lord. The subject above document, cadastral map of entire Sorutari village under Sonapur Mouza cannot be furnished as a whole landed are inscribed there in only in the trace map of the particular plot of land as required might be furnished if when necessary.
So this is the impugn.
Yes, my lord. And that was not challenged,
It is not under challenge.
not challenged. And a copy of Jamabandi Sita, part 1, given complaint petition, Ojit Khaklari is furnished, copy petition lost by Oloboro Student Union, copy of the 13/7 to ADC to circle officers packet.
Okay, then eviction is done on what basis?
Eviction is done on, my lord, because there is one of the notice has been passed. And on the basis of
Notice?
that, notice has been passed for other land, non-contested land, my lord. As per this, my lord, eviction has been started.
So according to you,
Yes,
the proceeding directed to be done by this court is not yet completed.
Yes, sir.
And other parties so far relating to some other land, you are not interested therein.
No, my lord, that case is not other land, I have interested other way. Because, my lord, here is an order, several order by the division.
No, no, just tell us, let us understand.
Huh.
There was a decision on complaint or whatsoever. Court says that, okay, give him the copy, hear it. We are not setting aside the notices of eviction so far relating to.
Be possible, my lord, that
Huh?
order has been. Give him.
No,
the
possible, okay, possible. We say that if it is cannot be given, cannot be given. Dismiss this writ petition.
Yes, sir.
Okay, fine. No problem on that. Do you propose to say that the other eviction done, because we are hearing on whether these two methods should be taken up.
Yes, my lord.
Their case is that these are related, so therefore both should be heard together. Okay? You say two are different. So do you propose to say that that land you have no interest in that?
We shall by other expedition that land. That particular.
That eviction is not as per this court's order
Yes, sir.
or the notice
Yes,
issued,
my lord.
which was subject matter of this writ petition.
That is not related to.
There
this,
were notice in
Yes, my
the,
lord.
which was under challenge in the
Yes, my
writ
lord.
petition. You
What?
implemented yourself as a respondent.
Yes, my lord.
So those notices were not set aside.
Yes, sir.
Do you propose to say that the eviction done in the other case do not arise out of those three notices?
Yes, my lord. Correct. This is only 15 bigha of land, man. And this is about 130 bigha of land, man.
So those were not subject matter of the earlier writ
This
petition.
petition.
Not this petition. I am
Yes, sir.
saying there were notices which were under challenge
Yes,
in the earlier writ proceeding.
Yes, sir.
Court says we are not setting aside this notice, but remand it back to
Yes,
the
sir.
circle officer to decide,
Yes, sir.
and after giving copy. You want to say,
And but one thing is that one thing is
answer
that
my question
in
first.
other cases, they have not mentioned that this petition is pending. Your lordship understand my point. So my humble submission before your lordship is the subject to my line of fairness
Where they have not made statement.
in other petition.
Now, that is, you said that we need not take up this
No,
matter.
no,
How
my
can we
lord.
go to that
Yes, my lord,
meeting?
that is why my lord,
So we are
now,
not going to that.
no, my lord, now they have said that both the petition are related. If the both petition are related, they have to mention in the writ petition.
We do not know whether mention on that. To examine that, we'll have to bring that
My
petition
humble
here.
submission before your lordship is that
No.
my humble submission is recorded this land, this particular land is not within the domain of that land, my lord. That land is suffering at 1030, 16, this is suffering land. Here, my lord, there
What
is an
suffering?
first separate.
Okay.
Yes, but your lordship kindly go to the, I only need this order, my lord. There is a my lord, order, my learned friend is appeared for other cases, my lord. Otherwise, this matter has become, my lord, never ending process, my lord. This is,
No, everything will end.
no, my lord. I submit, my lord. এই যে আপনি করছি যে সুপালি তুমি ওটা আজকে এটা করতে গেছে আসলে না তাই তো একটু বলেছি
This order has already been passed in the earlier case.
Yes, well, the same order may be passed.
No, this order has been passed. What we could, they are saying that both should be taken together. So you just tell us one thing that earlier.
Can I just come in?
My lord,
My learned friend is correct when he says in this case 15 bigha is involved.
Ah.
But my lord, in the other case, 130 bigha is involved, including this 15 bigha. Therefore, please have a look at this order at page number 6. The order which we have given.
It up to 2 purposes.
Yes, yes. Please come to page 6. How can my learned friend say, my lord, these are not related? Be that as it may, after taking.
Just a minute.
Yes, page 6, my lord. First subpara. Be that as it may, after taking note of the facts and circumstances of the case, as well as projections made at the bar, this court prima facie finds that there has been a cement factory in existence in this area since the year 2008. Operation of the cement factory, according to Sri So-and-so, is based on an integrated process involving Schedule N B land. It has been alleged that on 28/4/23, respondent number 4 has sealed the part of the land covered by Schedule A and B, thus compelling the petitioner to shut down the cement factory, although there is no formal order to that effect. If after detailed survey of the land and on demarcation of the land, it is found that petitioners are occupying part of the government land falling in tribal belt, then in that event, appropriate steps as may be permissible under law can always be initiated for eviction of intruders from such land. However, such an exercise will be permissible only after proper demarcation of the land. Therefore, until and unless such an exercise is carried out and completed, it will be wholly unjustified to shut down operation of the running factory, thereby causing serious injury to the interests of the petitioner, their workers. Situated thus, the following orders are passed. One is very important. Respondent number 1 to 4 shall initiate appropriate action to carry out.
Now this
detailed
court is
survey.
monitoring. Your grievance is your,
And my lord, those are non-cadastral land, that's why survey. This is not non-cadastral land.
huh?
This is not a non-cadastral land. huh?
Mr. Chaudhuri,
Madam,
court
problem
is monitoring your grievance.
No, my lord, my humble.
Yes, where is the
submission-
report?
No, my
We
humble-
want the report. If
My
it is
lord,
tribal,
report has
then
not
we'll.
given. I am very sorry to say, government has not given the report because these are the tribal people and they are the big people. So,
Mr. Chaudhuri,
Yes,
we are not in assembly or parliament.
yes.
We are in a,
Lordship is correct, my lord.
yes,
And there is an order of the division bench.
we
There
know that.
you clear all the Poitudpora.
That Pradut
And
Bora.
that land is included.
You
in
want the
Poitudpara
judgment,
land.
it is
Yes, my
here
lord.
for.
Yes, my lord. Poitudpara
To
land
help
is,
you, that is
land
with
also
me,
there, my
just
lord.
a click. Issue is, therefore, we can even monitor their activity in their case when tribal belt are being sought to be transferred.
My humble
This should be your prayer that this both matters should be taken together.
My lord, this matter may be taken on Monday along with this matter on Monday.
This is the,
Monday, my lord. That matter was fixed on
see,
Monday.
we'll ask them to give report
Yes,
because that interim order was subject to certain conditions.
Here, there is no interim order.
No, here no interim
Yes,
order,
ma'am.
but
One thing is that, my lord, my humble submission before your lordship, my lord, what the government has been done, that may be.
no,
put
that
to-
will be, therefore we ought to have, we can pass that order in this writ petition.
Monday, my lord. My lord, this is your lordship is say, correct? It is not parliament, assembly.
Yes,
But I am saying there is a division bench order, my lord. This order
and not a
before-
division
and
bench
division
taking a
bench order
PIL.
state that
Another
are not-
edition.
evict the tribal people, the non-tribal people from the tribal bill, then
No, no,
action should be
Mr.
taken. The
Mr.
deputy
Chaudhary.
commissioner.
Mr. Chaudhary,
Yes, madam.
we will see two things. One is that there are some right of some people under statute or rule whatsoever. We'll protect that. At the same time, if there are rules and there is violation, we'll monitor whether it has been properly executed. These two parts are there, but
Yes,
who is poor, who is illiterate, this is, we cannot make determination on the basis of this principle. We can make determination on the basis of the right of the people
Yes, madam.
and their duties.
My,
We cannot go beyond. That's why I'm saying this is a
yes, madam.
court, not a
Yes, madam.
place to say
My
all
humble
this.
submission is chapter 10, my lord, which is
We have seen that.
Some
We have
land
seen
and
that. We'll
revenue.
protect,
It is on the,
we will zealously protect.
my lord, my lord, that is
Heard
my lord.
Mr. K.
constitutional right.
Chaudhary, learned counsel for the petitioner, also Mr.
Other matter is
NNB,
18.
NNB Chaudhary, learned counsel for the respondents. Full stop. As agreed to by the learned counsel for the parties.
Well, matter may be fixed in first week of April.
Okay,
My lord,
uh,
next other matter is fixed on 18.
List this matter,
Ah,
list this matter,
no, it's not fixed. Other
Please-
matter is not fixed.
please-
My lord.
please
At
this
first week
matter,
of April, my lord.
please
we
this
mentioned
matter
it,
along with
for April.
WPC 2440/2023.
We
Kindly
mentioned
see
for April.
WPC 2440.
I'm mentioned good time.
Okay, okay. Along with schedule after 2 weeks.
2 weeks.
We'll say after. 2 weeks. That is the case
Yeah.
where your right will be protected.
Besides, my lord, kindly fix a date, my lord.
Give a date April first week. 4th of April.
Deep note.
May I please your lordship,
Mm,
Lord, the matter related to acquisition of land of the
Hmm.
petitioners. they have got Virat value,
Hmm.
but they have not got the land value. That is why they have approached this honorable court.
Hmm.
Fact is that Kala has forwarded.
Hmm.
Just last day, Lordship has happened. Kala has forwarded their name.
Hmm.
But our officer says,
Hmm.
no, it cannot be fair. For manual, government manual is there. Manual guideline is there. What land, how to pay,
Highways
what to
Act.
pay.
Hmm.
No, that is the that. Now, Lordship question has come up. Finally, 3G5.
Hmm.
Lordship has rightly pointed out, because if Kala has
Yes,
decided,
authority
Lordship-
might have
Yes,
objection.
Yes. Now, what next progress I'm telling you, Lord. Kala has, that was up to that I was agreeing.
Hmm.
On that day, last day.
Hmm.
Kala has once forwarded,
Hmm.
definitely 3G5 will come up
Hmm.
and check 1956. Because we have to go either party.
Hmm.
He or me can go to the
Yes, yes.
But in the meantime, I have placed one judge order
Hmm.
of this honorable court, that is in case of people work.
Hmm.
Similar length.
Hmm.
What happened? Now, Lordship has fixed today.
Hmm.
Then I have gone through the Vipulborg High case.
Hmm.
It is a little different.
Hmm.
Why different? Vipulborg High case was disposed of. His name was not forwarded by Kala.
Okay.
That is why this honorable court was pleased to dispose of
Hmm.
with an observation. If you have any grievances, last line is there, you have appropriate forum,
Hmm.
disposed of.
Hmm.
There is a difference now. Why? Because there are cases 11 and 12. This is Achyut and Tonuram case.
Hmm.
Their names are forwarded
Hmm.
by Kala. So, what manner, if it is go to arbitrator, it will be seeing, because initially, well, at the time of, it was a government land.
Hmm.
Then according to them, 1991 is well allotted for some
Settled land.
purpose.
It was a
for-
settled land. Therefore,
for
you will only
some-
Sirat. These are
something has come. Ultimately, decision has come. Now, as your lordship, the first point has come to now, it has to go to now arbitration. That is the theme of the body case, my lord.
This is 5396. Heard Mr. A. Buragoy, Learned Counsel for the petition.
Judgment today, order today.
Assailing an order dated 8/7/2023 issued by the General Manager, NHIDCL, PMU, Dibrugarh, within bracket respondent number 3, rejecting the claim for payment of compensation for acquiring the land, rejecting the claim of the petitioner, claim made by the petitioner for payment of compensation for acquiring the land. The present writ petition is filed. Full stop. Where is that order dated 8/7/2023?
But yeah, na, it petition there. Right, it
Full stop. The
Page number 59.
of the case is that
59.
by a notification dated 15/9/2014, the land of the petitioner measuring an area of 1 bigha 3 kathas 18 lessas covered by DAG number 103 at village 108 Huang FS Grant under Mauza Moran in the district of Dibrugarh was acquired for construction of 4-laning national highways 37 in the stretch of Dibrugarh. Accordingly, compensation with regard to Zirat has already been paid to the petitioner. Full stop. Where is the Kala's communication, Kala's decision?
Page number 52.
52.
52.
Full stop.
Mr. 19.
An award under 19G of the National Highway Act 1956 was also passed by the competent authority under the National Highways Act. In terms of the aforesaid award, the petitioner was granted compensation against the value of land under acquisition, 100% solatium on the amount in accordance with the 2000 Act 2013, and an additional compensation of 12% per annum on the market value of the land under the Act 2013, Fair Compensation Act 2013, and some other statutory payments. Full stop. Such award, however, by the impugned order dated 8/7/2023, the National Highways Authorities has declined to pay such pay compensation against land value,
Rapport,
land value,
60 feet.
On the ground that
60 meters per rapport.
Therefore, on the ground that in similar cases, such prayer for compensation has been rejected by the authorities of National Highway Authorities India Limited, inasmuch as rejected in terms of the guidelines of the National Highway Authorities of India Limited. Full stop.
One line may be waiting
Huh?
because that's why we have rejected.
Hmm.
Guideline, government land is not attended.
Huh.
At the time of publication of TA and TD under NHS, TA is notification lordship award, TD is declaration. It is why they have been rejected because that is in notification. NH 56 clearly says amount to be determined as per the notification dated notification of TA.
Okay.
That is why on the basis of that was it TA and TD it was shown as a government related region.
Full stop. Inasmuch as it is the case of the National Highway Authorities that this were recorded as government lands. We'll just
Yes,
say recorded as government lands.
Notification, that's what.
Government lands in terms of the notification issued under section
3A
3A and 3D of the of the Highways Act 1956.
Right.
Full stop. 1956. Where is the provision?
Provision 3G 5 million.
Okay.
Retail lordship may pay
National Highways Act, section 3Z, 3Z, within bracket 5
5.
of the National Highways Act 1960 56 prescribes that if the amount determined by the competent authority under subsection 1 or subsection 2 of the section 3Z is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. Thus, it is clear that once an award is passed under either under subsection 1 or subsection 2 of section 3Z by a competent authority, if either of the party is not satisfied with such award or satisfied with award, the only option left is to approach the authority of arbitrator under subsection 5 of section 3Z. Full stop. The National Highways Authorities, in the considered opinion of the court, in the scheme of the Act, after an award is passed, shall have no right to sit over such award except approaching the arbitrator in terms of the subsection 5 of section 3Z. That being the position, the impugned order dated 8/7/2023, which amounts to a decision to not to abide by the award of the competent authority is not sustainable in law. Inasmuch as the national highways authorities, as discussed herein above, shall have no right to sit over the award dated is
52.
52. Award dated 28th of December 2020.
20 December something.
2022. Accordingly, the impugned order dated so and so is set aside as squashed. However, parting with the record, it is made clear that the national higher authorities shall be at liberty to take recourse to the remedy available under section 3Z within 5 of the Act.
Provision of law.
As per law, in terms of the provision of law, because limitations questions will be there.
That is limitation. Generally, filing initial page, there is no limitation. Thereafter, it will come anyhow, in the lordship, I should get protection. It's a public body.
Okay.
Because there is a doubt is there. Again, we have to raise that question off record, I'm telling you.
But you have committed a mistake. You ought to have
We have
immediately.
committed mistake. That there is.
Okay, then this is so far relating to WPC 5396.
Yes, yes.
What about this 5179? Where is the impugned order 87? Same.
That will be.
Award,
What is that?
award dated in this case. Impugned order is 87.
Award is Miller 22 June, no, June 2022.
Okay,
By page Miller 55, lordship paid
okay. Award dated 22nd of June 2022.
22 award.
Are
That
ready
is
to sign
in
up.
case
Area
of-
to air sign synopsis. Okay. Dispose of both the cases.
Page, like,
Only passport for tactic. The rest is that.
Huh?
The rest is that.
Okay. Okay. Yes, Mr. Ghosh.
It's my lord, it's two petition, my lord. First, this petition, my lord, 6053 of 23,
60,
53 of 2023, my.
give that next item.
This petition pertains to my lord.
So your license was suspended.
That is suspended, my lord, subsequently. First, my the fact of the case is this, my lord. Actually, I have been running this purified store from 2020 to 2003, my. And I have about my lord that 2000.
What is that? Tell us first, what is the challenge in 6053
My
2020?
signals, I have challenged the, my lord, the propriety of this reserve,
Okay,
because that is in non-compliance with section 100, subsection 4 of the
okay,
CRPC.
fine. Then what is the second?
The second is fiction, my lord, that when, my lord, thereafter, my lord, they made an inquiry, my. Then my license was put under suspension, my lord. They made an inquiry. Then, my lord, they made another inquiry, my lord. So far their letter is concerned, my. We asked for all the documents, my lord. Say, look, we have to reply. You have conducted the one. We do not know what is there in the inquiry. Because the whole thing is initiated, my lord, on basis of a complaint. Some of the consumers made a complaint with the local MLA, my. He forwarded it to the deputy commissioner. On the basis of that entire search or whatever was done, suspension or whatever was done, the inquiry was conducted. No report was submitted to me. Then a second inquiry was conducted. That was also not submitted to me, my. So I challenge the propriety of the select because I have to give a fair opportunity. So I
Okay,
stand in the reply. Then my
Second writ petition is so far relating to your license has been cancelled.
not cancel, my. They have already taken a stand because on the other day instruction was put placed before your
But there
lordship.
was a
They have already made up the mind to cancel.
there
my.
was a interim order in the 6053 on 11.
Yes,
For that, they cannot proceed to cancel my license,
Yeah.
but otherwise they made up their mind because on
So
the
they have already done the inquiry.
Yes.
Your second case is that inquiry is not properly done.
not properly because of this, my lord, because it's a cardinal principle of nature.
Okay, now what can we do today?
What I respectfully submit.
You want to file an
I
affidavit?
have-
Okay, MSS.
And my lord, what I
Learned
respectfully
counsel for
submit,
the-
lordship, that a record may be called, entire matter
No,
will
no,
come
we
to
will
light.
call it,
Yes.
S. Bora learned counsel for the respondents that submits that she has received instruction and shall require
3 weeks time.
3 weeks time to file affidavit in opposition. Prayer is allowed. Good step. As the matter pertains to proposed pertains to and propose action for cancellation of the fair price shop license of the petitioner, and it is, and the such proceeding has already been completed. And the grievance of the petitioner is that such inquiry has been committed without following due process of law and without giving him any reasonable opportunity of hearing, for proper adjudication of this case, the learned state council also keep the record of the inquiry ready on the next date of, during the course of hearing.
Yes.
Uh,
It will depend, my lord, whether compliance with section 140 they are not.
Please, this matter after 3 weeks, interim order passed earlier shall continue.
What can you fix it? It's convenience of lord.
Given April
After.
after Bihu,
Or my lord, before.
give us
23rd April.
23rd of April 2024.
Apply.
Interim order to দিব। What is this?
On behalf of the respondent number 7, I pray that this matter be taken up 27th. And let Mr. Singh and senior counsel will be here on that day. Possible the 27th or 28th.
You are for the respondent.
I'm respondent number
You are
7.
operating the show.
No, there is a stay, my license has been stayed.
Okay. The learned counsel for the respondent number 7.
Good.
Praise for an adjournment. Prayer is allowed. List this matter on
27th.
27th of March. Possible? 27th of March 2020. Interim order pass earlier. Shall
No, there is
continue.
no interim. order.
No interim.
There is no interim.
Okay.
Consciously it was not.
Matter was heard by.
But it was not parted, not kept as part.
Heard at as per the 434. 27.
20. What you say?
My lord, I have been provided with a copy of
Ah.
that Malad report. As per that report, my lord,
Hmm.
it is difficult for my lord determining the age
Hmm.
by the ossification test.
Hmm.
Even then, my lord, the report has come
Hmm.
that my lord age is between 40 to 50.
Between
40 to 50.
40 to 50 as on date. So if we back
my lord,
down,
on
what should be the age at the minimum and maximum? Tell us.
Well-
We'll give the benefit. If it is 40, then what should be the
his
age?
age will be around my lord 10.
10. And if it is 50,
50, it will be 20.
what is this?
It's
Now
difficult.
tell us what to do in such a, we
My
have
lord,
done.
what happened in this case, my lord, before the my lord, the session judge,
Hmm.
this petitioner, my lord, that Ritu Bora, my lord.
Mm.
He has submitted one photo,
Mm.
which I have also got.
Mm.
My lord, he was directed to bring as photocopy was provided, my lord. He was directed to bring the origin.
Mm.
But he could not trace out. He stated before the court that is reflected in this order.
Mm. I have seen that.
Yes. He could,
What, as per that, what is
that
his-
order, my lord, his age will be around 15 years, my lord, on the date of occurrence. 26/1994.
15 years?
15. And if we see the age, my lord,
Hmm.
beneficial legislation, if it is
We benefit
40
should go to the,
yes, my lord, then we should
any
consider
judgment on that, anything?
my lord, right now, I do not have, my lord.
Okay, if possible, give something.
My lord.
Judgment, hearing concluded judgment.
Another thing, my lord, the appellant number 2, my lord, in the meantime, he has expired.
Okay,
Top on
so how, appellant to expired?
Bora, my lord.
Anything on, in your
My
hand?
lord, I have informed them, they told that, my lord, they have not yet obtained the, my lord, death certificate. So if anything is required, my lord, from the Gaupura, they can get it, my lord, and they can send it to.
You obtain a certificate in the meantime. Okay,
Right.
in the meantime, you obtain, we are delivering the judgment, we will not keep it pending.
Well,
Whatever material is there, that is there. Already you have dictated major part. So appellant number 2 gone.
yes, my
He has
Top on Bora, my lord.
Topon Bora. Nikhil Bhushan, Topon Bora. Then how many, this is
Total
the
total three is there, my lord.
only one
Appellant
remains.
number is Digonto, my lord.
Mm.
And number 2 is Topon, number
Digonto
3
is one, number 2 is Topon, and number 3 is Ritu.
Ritu.
Ritu is juvenile, 2 has already gone, only one remains.
One.
Okay.
I have sufficient before your lordship, my lord, is say occurrence of 1994.
We'll see, we'll see, we'll see.
I'm always.
Judgment is up. Facts are correct?
One or two,
Hmm?
one or two places, my lord.
Correct the facts.
Page 2,
Page 2.
report agreed to that, page 2.
Ah.
The first paragraph from the bottom, the fourth line.
Ah.
Starts with the word assume. Fifth line,
Fifth line from bottom.
my lord, of the first paragraph, The word is assume, my lord. First word.
Mr. Majumdar Land Council contends that there will be no effect on him being paid the first SCPS.
Then again on the down below, it is, the next line is also ACPS.
SCPS.
Then the next line will be come up as MS. Yes.
SCPS, na? Such
SCPS.
SCPS. Okay.
That one.
Ah.
In the second paragraph, my lord,
Hmm.
the second ACP becomes, again it will be ACP.
Okay.
The second is also is, then also we put find on page 3.
Hmm.
First paragraph, my lord.
Hmm.
Third line, that would be ACP.
Hmm.
And my lord, then again, my lord, the third paragraph, third line,
MSCP.
it should be ACP, my lord.
ICP, that is SCP.
And my lord, the fourth paragraph, second line, also the clear one.
Just a minute. This will be also SCP.
ACP.
Third paragraph.
My lord, yes.
Okay, then.
And the fourth paragraph, my lord, second line,
Hmm.
the second date, 1/3/2030 reflected, my lord, it should be 1/1/1/1.
1. Okay.
Otherwise, we agree.
This is
What is
fine.
what is-
Now the determination is required. First week of April, CAB.
Only one thing, my lord, that regarding the currency of punishment, my lord.
Okay, okay. Currency of punishment. Mr.
that-
Pegu further contents that
Unless the period of punishment gets expired, the claim for
submits that unless the period of punishment gets expired,
the claim for consideration during the said period cannot be taken up.
the claim for consideration of MSCP or SCP, SCP/MSCP cannot be considered. And therefore, the Therefore, the determination made by the respondents are correct. In support of such contention, Mr. Pegu relies on the decision of the Honorable Apex Court reported in 1995, 3 SCC 273. Okay? Judgment reserved. It would call up correction of the silo. Apne kuch lenge. Judgment reserved. Hearing concluded, judgment reserved. What was it?
Roll numbers, my lord, departmental candidate, same number. His case is that he appeared as a departmental candidate.
Did we dictate something on that last?
No, my lord. The records are with my.
Records are with us. Where is the record? Mr. Deka.
Lord.
Difficult. Now from bench 4 to, we thought that we'll be in bench 3, will continue. Will you mind releasing it and sending it to bench 3? You have done your job. We have also given.
Oh, my lord.
No, just tell us that. Otherwise, we'll take the burden. No issue on that. You have argued, no doubt about it. You have also argued, he has produced record. We have also applied our mind.
My lord, it will be injustice if we deprive him because he
No,
is
no, that
serving-
is not the issue. What I am asking.
he is serving since last 50
No,
years.
no, we are not saying that. What we are saying that this is a part-heard matter. Should we release it? Go to the bench 3.
Let's see.
Because if bench is taking bench 4 and 5.
And your
And we have
lordship,
not dictated anything. In other case, we have dictated.
Yes.
If you don't mind.
Why, and your lord-
Since this bench is this court is taking up bench 4 and 5 matters. Though matter was heard at some length, the matter is released from court. Okay, and registry to release this matter. When?
After you, then
I'm feeling bad, of course, but okay. Let's okay. Everybody ask their registry. Okay, we'll ensure that matter is listed. Okay.
Madam, may I? take
Okay,
the-
record.
take the record?
Keep the record.
DPO.
এই গরম লাগছে এসিটা কে বললাম
Okay.
yes
So last order dated 08.
Mm. Who represents municipal administration department? So what is your stand?
One instruction I have received today
Hmm.
from the district commissioner deputy.
Hmm.
But that municipal administration part is not there. It is not included.
Because here issue is, you are the state in the municipal administration department is the competent authority.
Right.
When notice is issued for proposing inclusion on exclusion of a or creation of a notified area,
Right.
municipal board, or then people are having right to file an objection that is to be answered.
Right.
Now, what is your
Only
stance?
objection was hard.
Hmm.
The hearing took place. But what had happened after that?
So
whether
if
some-
objection has taken place, you have issued a notification, gazette notification, then it deems that that has been rejected.
Reject.
Now, what is the remedy against that?
Might, that
That is another aspect of the matter. And to what extent, until and unless you they satisfy, we can entertain. So let us do one thing. You at least have that instruction that it was heard and notification was issued the gazette notice. Can you have the record of this?
yes, record answer.
Record is
we
there.
have- We have.
Okay, if record is received,
I can go to the record and.
you go through the record and we'll fix it next week. We'll just only determination 2015 method required is whether you have heard them or
That is
any
what
determination is made on the
It
basis
appears
of.
from there itself, my lord,
Hmm.
our evidence, with that we have heard them, but what order?
Now, whether it will, where is the notification? If hearing is concluded, notification is issued,
That's good.
meaning thereby it was, there should be definitely something on record.
I'll take.
Okay,
the record.
pursuant to this court's order dated 8/2/2024, Mr. Talukdar Learned Senior Counsel is present representing Municipal Administration Department, Government of Assam. Registry to list this matter on the next date fixed, reflecting name of Mr. Talukdar as the counsel.
Well, I'll go to the record.
Okay,
So the
Mr.
language
Mr.
you-
Talukdar submits that he has received the record in so far relating to the notification issued under section under section subsection 1 of section 334 of the Assam Municipal Act 1956. And he will require some time to go through the same and apprise this court.
you want to-
Accordingly, matter stands adjourned and be listed on next week. I give it a small issues 2015 will be.
In their instruction, my lord, language is very hard, so I don't want to.
No, no problem on that. 19th. 19th.
With the record.
মাতি দিয়া এইটো টাইম বিচাৰিছে কিয় বিচাৰিছে চাই লওক এইকেইটা মাতি দিয়া মাতি শেষ কৰা Yes,
There is
why you need time? What is the issue? Tell us first.
we are challenging the executive challenge to the 2019 by tax recovery officer and attachment order dated 12,018.
Hmm. Who is representing the taxation? B.N. Gogoi, Seni Council.
We have taken personal necessary.
You have not taken consent from the court. Is that it? Have you filed any note that we are seeking adjournment on consent? And that consent is not binding upon us. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on divided. Why this matter is listed for hearing?
Opposite,
Rule issued?
no, they
Okay, list this matter. Raised it to list this matter in the admission column on the next date fix.
there is
The interim order pass earlier shall continue till the next date of listing. Give a date. 9th of April.
a
Yes.
But hearing case, my lord, non-payment of ex gratia payment
Mm.
with respect to the land which was acquired by the government of Assam
Mm.
and handed over to the TRT.
Handed over to
TRT. Yes, sir.
non-payment of
They are defined as ex gratia amount,
under what authority?
but we are claiming compensation because our land, Patta land has been acquired.
Through land acquisition process.
No. That is the trust.
Lordship, it
Now
was
kindly see-
initially
Ah.
process started under LAX, my lord,
Mm.
section 4 notice, section 6
Mm.
notice. Then subsequently it was found that the land falls within the forest. So forest, ultimately that was de-acquired, my lord. Then forest has handed over it to DRT. So some compensation was assessed. And DRTO say that that amount has been released, but I do not know, that has not come to us.
My lord,
Forest maybe, they may be having
my
that.
lord, what affidavit?
What is DRDO? This defense?
Defense, defense,
My
it's,
lord, kindly see the page 74, running page. This letter is there. Because when they de-acquired our land with respect to the petitioner's land, they are Patta land. So they have not.
70?
74. Running page. Okay.
Yes.
To the chief construction engineer, R&D.
74 is the Assam Gazette অধিগ্রহণ করিব বিচৰা মাটিৰ চৌহদ.
74.
Yes.
75. Running page.
Running case.
It is filed by
Affidavit.
additional affidavit
It's a part of additional affidavit
of the
by
deputy commissioner.
Srimati Krithi Jali.
Yes, deputy commissioner. Yes.
Annexer?
That page 37 can list it.
Page
Internal page,
Page 37.
internal part.
Internal page 37.
7/8/2009.
See, this additional affidavit is having
My lord, initially they have filed only
Let's-
affidavit.
wait. This is having one annexer dated 28th of February 2023. This is the first annexer. Kirti Jali filed an additional affidavit in compliance of order dated 3/1/2023.
Yes,
Okay? That affidavit contains 2 pages. An annexer starts at the communication dated 28th of February 2023.
that initially they have filed
No, you want to see me which page?
page
Which documents? Tell us.
7/8/2009.
7/8/2019. One is 18th August 2010 is there. You go through it, clear the
My
pagination.
lord, I.
You just,
Because why it has confused, earlier they have filed only affidavit. Their court asked why you have not filed the document. Subsequently, they have.
no, that may be, but that is a history. Present is that we want a pagination which tallies with you so that you can proceed in the matter.
Yes, I am showing.
Okay, call the next case. You correct it, we'll call the next case in the meantime. Hmm?
This litigation is directed against a private party, and there are two orders, my lord, by this one report regarding the maintainability of the rate petition.
Hmm.
In fact, the area manager in his personal capacity has filed this case.
Now, who is representing the APDCL?
Lord, I discussed the matter with Vastav Pathak. He told me that he is not appearing because he is
Who?
KP Pathak.
Area manager IRCA to APDCL. None appears for the petitioner on call. Dismiss this writ petition for non-compliance. Interim order, if any, stands vacated.
One, my lord, got rare. I was supposed to file the affidavit because of the shifting of the office in the building, my lord.
Now tell us, here is a legal issue. Any
And
affidavit is
without
required.
a Spot note, my lord, they are praying, my lord, by Tuesday, my lord, I will have a inspection. On Tuesday, lordship may dispose it of by any means.
Now, see, here is a issue whether our order has subsequent order after remand has been passed in proper perspective and whether it is in derogation of the earlier judgment of this course and determination made. This is the issue.
Yes. Even then, my lord, that technical issues are involved. On Tuesday, my lord, by any means.
Saraf was apprehending this.
My lord, yesterday I informed. my lord,
Anyway, a very small issue. When?
It appears to be, my lord, let that open up, my lord, on Tuesday or Wednesday, Thursday. Tuesday or Thursday, my lord, I won't pray for too long. On
How many
21st.
matters are fixed? When? Not this
Tuesday, my lord.
possible? How many matters are fixed? 21st.
21st, the series and other matters are there, but it will not take time. 20 matters are there.
Normal 20.
19th?
19
19th? File an affidavit. 19th.
19th.
for further hearing.
Huh?
For further hearing.
It will come before this.
So it goes here and there.
It will not go. At least
For next week, lord.
next week. Thereafter, we do not.
Some disposal maybe there, but old cases are here.
No, that's why we are not taking up old cases. No doubt about it. But see, almost we have finished the list. How many matters remains? 2 matters, not even one. Wastage, criminal wastage of judicial time.
Some matters are there, but the matters. I will keep the. Bench five.
Bench five. Let us see next week what happens. Otherwise, yes, call the next case. Yes, Talukdar.
My lord, this case, my lord, based on a very short campus. In fact, what has happened, my lord, there is a statute by the state legislature laying down, my lord, the procedure.
Procedure for?
For reclassification of land.
Okay.
And the statute, my lord, is known as the Assam Agricultural Land. Bracket regulation of declassification and
where do you get that?
My lord,
where do you?
perhaps I have given the gazette, my lord, notification part record. It may be on the record. If your lordship does not find it, my lord, one affidavit has been filed. Your lordship may take up the affidavit. They
give the National Highways Act also. Affidavit, it is along with the affidavit.
There is one affidavit file, your lordship may take up that affidavit.
Affidavit
Recently
filed by on behalf of respondent number 3.
Yes, yes. Respondent number 2, my lord.
Respondent number
3
2.
is the deputy commissioner. Lordship may take up this one. I can do. Please, lordship may take up this. It's convenient, madam. I have marked there, so.
Okay,
Yes, I have filed for the NHA district.
okay.
Now, your lordship will see,
Hmm.
my lord, I'll draw your lordship's attention to the authority, my lord, under the act.
Hmm.
And these authorities are relevant.
Now, facts is that you applied for change of class or change of the use of land,
Class of the land.
class of the land. When you file, just let us understand the
My-
facts part.
my lord. No,
The dates.
My-
Dates will be,
that will be.
let us
crucial.
understand.
Yes, that could be crucial, my lord. My lord, we have stated in para 12,
5/12/2023.
yes. Initially, my lord, some manually, my lord, we submitted, but
Mhm.
since, my lord, that RTPS, Sewa
Okay, that-
Setu has come in, so that manual applications were not accepted. Eventually, we were asked, my lord, to submit through online. So the dates are 5/12/23, 1/12/23, 11/12/23 in respect of this.
5/12/2023.
It's 1/12/23
Mm.
and 11/12/23 for purpose of this petition.
Filed.
Right.
Okay, then.
Thereafter,
Hmm.
the relevant dates, my lord, are NOC was issued by the Assistant Director of Agriculture, Karimganj.
Okay, it is classic for agricultural to industrial.
Industrial.
We are going for final disposal.
Yes.
Agree to industrial.
In fact, these dates, my lord.
Any pages here?
Here.
First,
my-
we want to understand the factual,
Yes.
then we'll come
My
to the
lord,
law point.
correct.
Just in
Correct.
short,
Correct.
page.
Lord, it's correct. That, my lord, I have submitted the annex report, my lord, that your lordship will find.
Hmm.
It starts from annexure 4, my lord. Page 63.
Page 63.
Yes,
Okay.
and this is letter dated 4/12/23.
Okay.
Address to the circle of.
Now, when NSC has given,
My lord, the DLC meeting
Hmm.
that was held on,
Hmm.
my lord, 20/12/23.
2012,
23.
2023 DLC meeting.
Yes. And before that.
Hmm.
before- Lordship will also take note of, my lord, annexure 3 series.
Hmm.
These are acknowledgement of the application.
I do not think they have disputed it.
Yes, no, not.
Application is not
Not
disputed.
this, not. Thereafter, DLC meeting, my lord, 2012/23.
Hmm.
And
Page, anything, any reference to the
yes,
DLC
yes,
meeting?
yes, correct. That reference, your lordship will find at page. It starts from page, my lord, 74. This shows, my lord, the meeting has been rescheduled on 2012/23.
Okay.
Thereafter, my lord, 74 onwards,
Hmm.
the minutes, my lord, in
Okay.
fact, who were the officers,
Hmm.
that has been shown.
Hmm.
And thereafter, my lord, the minutes, my lord, has been.
Where is the
Page
minutes?
76, my lord.
Page
Minutes.
76.
Yes, minutes of the district level committee.
That is that minutes of the meeting dated 22nd of December 2023.
20.
What is the conclusion of the meeting?
My lord, in fact, this was the, in fact, your lordship will see,
Hmm.
those NOCs, my lord, approved by the deputy commissioner were placed before the DLC.
Okay.
So therefore, my lord, as on date, when this my lord, DLC is set,
Hmm.
so it was held, my lord, or observed that there is no, my lord, optics. It can be, my lord, classified.
NOC was given by the circle officer
Yes,
on
that was approved by the, my lord, deputy commissioner.
NOC was given on which date? By the circle officer?
Different dates, my lord. My lord, in fact, basing on the reports of the Director of Agriculture, Karimganj,
Hmm.
those reports were submitted by the circle officer,
Mm.
but this is not on record.
Mm.
What I can show your lordships, my lord,
Mm.
is at page, my lord, 77,
Mm.
which says, my lord, list of NOC
Mm.
approved by deputy commissioner
Mm.
to be placed before DL.
Page,
So, page 77.
okay, page 76.
So this, my lord, was approved by the deputy commissioner. That
Now,
NOC,
it-
NOC
on
was
on the basis of that, on 22nd of 12,
Yes.
it was accepted.
accepted. The
Okay.
DLC, my lord.
Okay.
And your lordship will see 76, this is relevant.
Mm.
Last part,
Mm.
the circle officer Nilam Bazar
Mm.
has proposed the reclassification of aforesaid land
Mm.
on the basis of zonal valuation proposed to the government
Mm.
for approval by letter number so and so dated 12/7/23.
Mm.
A copy of the letter of circle officer Nilam Bazar is enclosed herewith for ready reference.
Mm.
So that has been accepted by DLC.
Mm.
Now, when the process, my lord, was completed, sort of acceptance of, my lord, the premium.
Mm.
Once the premium is accepted, my lord, with
When premium was
premium was not given. In the meantime,
Mm.
my lord, the NHDC, my lord, intervened.
okay, how they intervene?
They, my lord, issued a letter,
Hmm.
my lord, at page 79.
What is there? What is the dated letter
Yes,
dated?
letter dated 2/1/24.
212024.
24. Yes.
What they proceed?
Yes, my lord, the deputy general manager, NHIDCL, addressed to deputy commissioner, my lord, by this letter, is the, my lord, states subject.
Page,
Let us-
page,
Page, my lord, 79.
what it says?
It says, I'm reading it out, my lord.
Hmm.
Page
Page
79.
just a minute.
Yes.
Hmm.
As you are aware, NHIDCL is undertaking co-leaning of Badarpur so-and-so section of NH08 and land acquisition for the same is under progress. It has come to notice of this office that commercial diversions change in class of several lands have taken place till date. There is a high probability that landowners might have intentionally applied for change of land classification for obtaining higher compensation.
Then what happened?
Yes, now he, my lord, he has referred to some Supreme Court judgment, which is not, my lord, very vague, not cited.
Mm.
Then it is stated, therefore it is kindly requested not to consider any change in classification of land for which application has been made by landowner on or after 15/9/23.
So impugned is the page 80.
Impugn is page 8. Now, if your lordship comes to the deputy commissioner's, my lord, letter,
Just a minute, just a minute.
Yeah.
This is letter is 8 January.
8 January, my lord, this is the letter is 8 January. Correct.
Okay.
Now, I take your lordship to the impugn letter.
Hmm.
It starts with, my lord, the statement in pursuance of the letter number so and so dated 2/1/24. Received from Deputy General Manager.
Now tell us
NHIDCL.
whether any notification was issued as on date.
No.
On that date.
No, this is my case.
When the notifications of the highways were issued,
Yes. There is affidavit. They have filed the affidavit, my lord. Deputy
we need the
Commissioner.
dates because
Yes.
these dates are crucial.
Crucial, correct. I'll give the date.
Two issues here.
My lord.
First issue is whether Deputy Commissioner would have issued the impugn order only on the basis of the request of the NHIDCL. Because as on date, according to you, no land acquisition process under the Highways Act was initiated.
Absolutely.
Therefore, your argument will be this authority as having no power to ask the Deputy Commissioner, and at the same time, the reason for cancellation is not in conformity with the extraordinary, this is what we call it, as some agricultural land Reclassification Act.
Correct.
This is your case.
Right.
Second issue is, this is basically your case. But in the meantime, the land was, notification was issued. It was vested on the state. Now, therefore, in that circumstances, whether in exercise of power of judicial review, we can ask the deputy commissioner as on date to decide your claim in terms of the act. This is the second issue. Third issue is, when this will be ancillary issue, when on the date of issuance of notification, it was not finally concluded, or the proceeding under the Act of 2015 was inconclusive, whether we can direct to initiate or continue with the process in exercise of power under judicial review. This is the three issues. That's all? Okay. Now, apparently, had there not been an land acquisition proceeding in the meantime, this order is not sustainable under Deputy Commissioner's order. Subject to what you say. It is apparently expressly not in terms of the act. Where is the authority of national highways that somebody might know, there might have a right accrued prior to that it has already become industrial land, therefore process was initiated. But before you issue a notification, there was a request from the NHL DCL, do not do, and they say will not do. Let us see the scheme of the act.
Yes. Because the state has to defend its decision or DC. But under NHIDCL, the concern of NHIDCL was my lord, the whole purpose behind such application for reclassification was to, my lord, to fluctuate, higher fluctuate manage compensation money. That is,
No,
that is the only
this
purpose.
can be your objection. That apparently, that is the reason you have given.
Yes.
But that may be a very good ground,
Why not?
very good reason. That may be reality. But whether a deputy commissioner in exercise of power under an statute can act in a manner as has been wished by an extra, what will say, extraneous authority.
Let him, I'll argue my point.
These are the questions.
Yes, I'll show my,
No,
what is.
facts is different. You may be correct.
Yes.
We may have a satisfaction, full satisfaction that yes, this has been done with the interest of so. But can there be a reason until and unless you can prescribe or show that the act authorizes this such kind course of action either in Highways Act or the rules from there under? Because you'll have to assume an authority, a power and authority under Highways Act to do something. You are non-existent until and unless a notice is issued, first notice is issued.
I'll actually, let him. Our concern is to save money, because if.
No, we appreciate.
Yes.
We appreciate. We are here. In the first half also we said we are here neither sitting in parliament or assembly. We are here to decide the issues as per law, not by any other. That's why our eyes are closed.
My lord, since the stand of the deputy commissioner is crucial. So if I take your lordship, my lord, to the affidavit filed by the deputy commissioner, is that start from page 84.
Page
84. Start from page
Okay.
84. I'll refer to some of the paragraphs which may be relevant, my lord, not the entire. This is the, now it is known as district commissioner instead of deputy commissioner. So your lordship will kindly skip to para 9. I'll read out some of the, my lord, paragraph which will show whether there was any application of mine at all by the deputy commissioner. Before that, my lord, if I take your lordship to this.
No,
I think.
you need not go to the affidavit. That we are more than satisfied.
Fine.
Reading the order itself.
Yes, correct.
Because deputy commissioner has not at all applied
Yes.
to its mind to the relevant facts.
Yes.
it could have said that, okay, stall this process. Or that this is under this provision, we are not proceeding with this. If he might have a power, we do not know. Therefore, we need to see the scheme of the act, whether anything relatable to land acquisition. And what will happen in such a situation?
My lord, in fact,
Every action of an authority is done under law.
it has to be done
Mm.
under law. Yes. In fact, if your lordship comes to page 89,
Mm.
subsequent to the issuance of the letter by the, my lord, NHDC and the consequent impugn order, what the deputy commissioner had done, he has, my lord, stated here.
Cancel for the sake of further loss to the government exchequer. How it can be a loss, assuming for a moment. These are the debatable. Don't take that we have taken a view. Mr. Gogoi. See, suppose a land has already, while you reclassify the land, you must have a satisfaction. Not you. He will have to have a satisfaction that yes, this class of this land has changed. Because of this reason, we have inquired, we have found, and we have the satisfaction. Class is changed. So that according to you, it's a loss to the exchequer. According to the petitioner, it is a deprivation of their actual value. Isn't it? But crucial question is the second part.
My lord also has to see the attending facts, the act itself, which governs the whole this exercise of classification. What kind of land can be, my lord, applied for, and after application, after my lord. if
You
it-
say that we will have to see it over the decision of the DLC to say that no, this was wrong. Let the deputy commissioner say. Deputy
Right.
commissioner could have said this. Could have said this.
Right.
Whole deputy commissioner case is not that this is a fraud played upon us. Deputy commissioner case is so and so has requested, so cancel it.
NHIDC
Mm.
now has assumed the power of deputy commissioner.
Deputy commissioner.
And the deputy commissioner is, my lord, acting on their
But
behalf.
you will have to address first part, okay, we'll hear him. But second part is what will happen in the given circumstances of the case when it has not attained a finality of change of classification.
TD has also come now.
In the meantime, the notice has been issued. So what will happen? Because law in certain cases, it has been said that even office noting and decision in principle, until and unless it is notified, is not a decision at all. What is the judgment? There are some minings and you will know it.
I forgot, but that principle I know, my lord, mere approval doesn't give finality.
So
That is-
therefore, we need to look into the scheme.
Right.
That is the area where you will have to address.
My lord, correct. If your lordship comes to the scheme.
Mm.
Lordship will, my lord, firstly, I take your lordship, since your lordship is satisfied
Mm.
that the NHIDC is extraneous to this act,
Mm.
so I'm not required to come to the definitions of the
Mm.
authorities. Who are the authorities?
Mm.
But I simply say under 2C, there is circle of that, E deputy commissioner,
Mm.
F the government.
Mm.
And there is another, my lord, authority known as local authority, K.
Mm.
Local authority means an includes an urban development authority or a Gaon Panchayat in rural area or any other authority which the government may from time to time notify local authority under whose
Now, where is the procedure?
Yes, procedure law
Five.
will find five.
Five.
Yes. Follow this assumes follow significant in respect.
Now, what is what the satisfaction is required to classify?
Number 4, section 4, madam.
Section 4.
Section 4, what kind of land? How to proceed? Certain requisites are there. Prerequisites.
And what is the remedy against the decision of classification or non-consideration of classification?
My lord, there is a remedy for appeal.
Hmm.
Any person aggrieved by an order, section 70, order of the deputy commissioner.
Why I'm saying is that because Gogoi is having in a situation, some person might have a anxiety It's by fraud, it has been done. So that's why I'm asking what is the remedy? You will have a remedy if it is not granted. Suppose it is granted, then somebody may be aggrieved that it ought not to have, like Mr. Gogoi.
Yes.
Isn't it?
Right.
So that's why that is a passing query.
My lord, there is a provision,
Hmm.
my lord, vesting with the power of the government also.
Hmm.
Your lordship comes to 15. This act, my lord, has balanced, my lord, the equity. This say, notwithstanding 15(1), notwithstanding anything contained in this act, the government in the revenue department in the public interest may, by notification in the official gazette, restrict or prohibit the establishment of any non-agricultural activity in area within the school. So that power rests with the government. It can either prohibit or restrict.
So your stage cancellation was done at stage 5. Stage 5. So, sub-rules, that means subsection 5. Subsection 5.
Right.
Now, what was required to be done is subsection 6 in principle applicable and subsection 7.
My
Then
lord,
only NOC.
in principle, my lord, approval has been granted.
Hmm.
Because that has to be granted by the DLC under subsection 4.
Okay,
That has been granted.
that has been
Now,
granted.
Yes, only, my lord, the premium was required to be accepted.
So meaning thereby only 6 and 7 remains. Subsection 6 and subsection 7.
Huh.
Isn't it?
No, my lord, in fact,
In
Sub-
principle, approval for
accorded.
itself mandatory on the part of the
Remit
owner
the
to remit the
prescribed
prescribed
premium. This
reclassification
is
premium.
premium.
So that was notified to you.
In fact, that was not notified.
Okay.
That was, in the meantime, my lord, it has come in.
Hmm.
And I was
Very
willing to pay.
limited issue now. Now,
I was-
whether we can ask at this stage to the deputy commissioner to continue with the further proceeding of the determination under subsection 5. Now, for that, you will have to answer what will be the correlation between the notification, whether a proceeding already started under this act shall stop in the meantime by virtue of a notification and vesting of the land upon the highways authorities, or it can still continue. If it can continue, we can pass a direction, continue with that irrespective of 3G. Irrespective of section 3G,
3D.
3D. Notice, first notice,
It is 3A, my lord. Now it is
very limited.
3A has come, 3D has also come.
In 3A, my lord, our lands are declared as, my lord, industrial. Okay.
When therefore give a date, all these mix-up dates from your date of application with including the notification under the Highways Act, so that we can make a determination. Whether these two action or two proceeding can parallelly proceed. If it can parallelly proceed, very well. And if it cannot, he will say it cannot. And he will say it can proceed by interpreting both the acts.
That same act, my lord, will go kindly come to section 10 of the act,
Which act?
that Assam Act, section 10. That is why I'm saying the attending facts have to be looked in, section 10, my lord. But after assuming everything was wrong, everything was in their favor, the respondents are all along wrong, reclassification was also done. My lord, after reclassification, that land has to be put to use to non-agricultural land within, my lord, 3 years. In this case, my lord, 3D has come.
No, this is a mandate condition
Yes.
of an agriculture. Suppose, forget about your request and all.
Fine.
A land is classified from agricultural to industrial. Okay, fine. Within 6 months, assume that your officer has not written, they have not
Yes,
cancelled.
yes, yes.
Within 6 months, a notice is issued. Now what will happen? Will you say then, no, you have not, will you wait for 3 years? You cannot wait because you have already taken over the land. Issue is not there. Issue is whether admittedly proceeding did not conclude. When notification was issued, proceeding did not conclude. Okay, suppose we say that the reason for cancellation of the proceeding is bad, set aside. Now, next question we'll have to answer whether the proceeding can still continue when a notification is issued. There is a correlation.
Yes, ma'am.
What he argues, that will depend. He might argue that a land is classified as industrial use when in fact it has become an industrial land. So having the satisfaction on that day, already it was a satisfaction of the authority that it has become industrial. So therefore, Highways Act should not be a bar for continuing this process because compensation means a just compensation for a landowner. That can be his argument. So we'll have to balance it. That is the only argument. Will you do it today?
My lord, in fact, I have to satisfy your
Ah.
some authority.
In fact, I also have a similar matter, my lord, 1996 10 SSC, my lord. Whether
Give it to him.
yes, sale deed was brought into the compensation.
Hmm.
There the court.
No, I think that is in the case of reference might be.
No, my lord, this is a land acquisition, 1996 10 SSC 39, Pelek Lal.
Hmm.
But here it says, my lord, the court has to look into.
Hmm.
It's not a, in principle or in general, it has allowed this kind of, but one has to
No,
look
that
into-
is to be looked into.
The attending facts have to look into.
Yes, it is be looked into when a compensation is determined.
My lord.
We are not determining any compensation. We are determining the authority and contradiction between or
Yes.
correlation between two acts. That's all. We'll interpret whether it will survive or it will fall. That's all. If it survives, it is the deputy commissioner who will have to decide, not we.
My lord.
If it will not survive, then everything goes.
Yes.
We'll say that the reason may be bad, but otherwise we cannot issue a direction for continuation of that. Talukdar,
Well,
that much
any other day, I'll satisfy.
limited.
Whether there is any conflict between the two states.
That to choose or whether that notification, land acquisition notification under Highways Act, because law is well settled, moment a notification is issued, the land vests in the government, not on you. So if land vests in the government, now whether a proceeding under a different statute in the midway, which was in the midway, forget about the cancellation, can continue. Suppose assuming for a moment that there was no cancellation, but it did not attain the finality, in the meantime notification is issued. What will happen? That will answer your question. There may be two parts. One, they will argue that it is vested. There is no question of redetermination. It is vested on the government. So therefore, you don't have any further right for reclassification. It will be meaningless. Your case would be classification is based on the already change of class. This is only a formality. And therefore, even if it land is acquired, I am entitled for higher compensation. So therefore, there is no contradiction between them. This is rather required for determination of the actual compensation. But you'll have to satisfy because you'll have
I
to
would say, my lord, that it is a case of determination of compensation.
compensation.
My land is already industrial land. You determine how much I can. That would be my argument. I'll show some authority.
Now, to come to a conclusion that your land is agricultural land, there is no conclusive determination. Therefore, the important question is whether it can continue to have a conclusion.
I'll check with the authorities, my lord, if their compensation is allowed. 3 rupees will go to 90 rupees. 30 rupees will go to.
There is a judgment. Some South Kamrup, this Sen Mahal.
Yes.
South Kamrup Sen Mahal, delivered by my Lord Justice Arup Goswami and affirmed by Division Bench consisting of Justice Ajit Singh and Justice Manojit Bhuya. I can find it out. here this principle has been decided because there was a proceeding, but that may help you. You will also go through it. There is a proceeding regarding grant of permission by the authority, that forest authority, for de-reservation for Sand Mahal. Then in that case, everything was done. Only formal order was supposed to be issued. In the meantime, 2013 Act came, wherein it was declared that every settlement should be under tender. So this committee challenged that proceeding and said that now you cannot further proceed it because you'll have to do it through tender. Now court upheld that contention and said that until and unless it is finally issued, it will not have the finality, and therefore, see, in view of the new act, which mandates a prescription of tender, that cannot be granted to the earlier lessee, who in fact got the permission. Minister also approved, in principle approved by the central minister. But court says no. Then it was to division bench affirmed it. And what we learned is that it went to Supreme Court, then that was also dismissed. It was happened to be argued by me.
I will well go through it.
Dakhin Kamrup.
Then.
Sand Mahal, something like that. Okay. When? No. Give up. This is an important issue. Immediately before Holi. 27 after Holi. Before Holi. 22nd. Heard at some length. This matter for further hearing on 27th of March. This is the issue. We just addressed it. We will take half an hour and we'll dictate in the open court. Where is that? You keep that, huh? You keep it. আগতেও দিছিলে মিসপ্লেস হয়েছে জাস্ট পিন আপ করিবা পিন আপ করে একটু বুঝতে পারো না একটু আয়া ওরে একটু
Hold it. But I checked it up, but some translated book page not page 85.
Yes.
85. Right.
Okay.
Keep going. To the construction engineer, DRDO, Ministry of Defense, placement of so-and-so in favor of the Deputy Commissioner Kamrup being the aggregate amount in respect of the project affected people of 33 bigha 10 lesser in connection with the acquisition of land for establishment of DRDO in Kamrup district. Kindly refer to the letter sent by so-and-so addressed to fight with an ex-gratia proposal amounting to rupees so-and-so was forwarded to you for placement of rupees so-and-so in favor of the Deputy Commissioner Kamrup for onward release of payment to the project.
Just tell me, where is the notice of acquisition?
No, there was no note. Then kindly see next page.
There is no notice of acquisition. Now, how discuss? Let us understand the facts. How land was taken from you?
Yes, that kindly see page 38. How it has come. Page 86.
Yes.
86. Detailed discussion has been made in the meeting, and from the meeting itself, it reflects that. Kindly see the place before the house, paragraph number 1. It was noted that Naukuita village was declared as reserve forest in the year 1971 and Divisional Forest Officer North Kamrup Division present in the meeting informed that from their available forest record, no compensation was paid to any person while declaring Naupoita village as a reserve forest in the year 1971. As there was no pattadars in the village Naupoita as per their record when it was so declared. It is noted from the
Just a minute, just a minute.
Yes.
Okay, now we understand that this was a land acquisition was not given. According to them, it was a forest land. You were settled there wrongly by mistake. Government by mistake done it. So we'll have to cancel the allotment and need to give an alternative land. And but however, with a Zirat.
Alternative land were given to other people.
Huh.
Our land is for within the core area of patta land. Suppose in and around forest land is there, in between there is a patta land. In that patta land,
How can there be, if a notification is given that this is a forest land?
no, it happens. It
No,
happens.
it may happen, but it is not permissible. If it is a forest, it's a forest.
Forest is
Whether your land was within the forest notification.
no, that is the
Now, who will determine all this?
no, that has already been determined.
Where is
Has
that?
already determined that our land was the patta land.
Where is that?
In the,
Determined by whom?
it was discussed in the meeting as well as on the from the inquiry also. Inquiry has been done.
Okay, tell us. You
Elsewhere.
show us that relevant portion that
Yes.
it was also held
Yes.
that your land is within that land and it's a patta land. Show us that findings.
Page 86, paragraph 4.
Yes.
86, paragraph
Page 86.
it is just now which I have.
Hey.
86, 85 and 86. 85 I don't earlier. Now 86.
How can this be hard?
86.
Wait.
Yeah. Deliberation of official of DRDO present informed that out of 190 bigger one.
Don't read. Our whole file is in a mess. What is this? Fine. Because not be possible to hear this method today.
At last,
No, this is not possible to hear a case like this. Whole record is in mess. While hearing this method, it is seen that the registry has not done the pagination properly. Accordingly, registry to do the proper pagination of this case and list this matter on.
because the original owner died. Now the legal year has come.
What is your stand?
Look, our stand is very clear. Those are forest land.
Because there was a minute in 1971 that the forest was areas declared, there was no patatar. However, only an inquiry officer says there may be some probable patatar. That is it. And deduct compensation, ex gratia compensation has been assessed in our record. That is not released. That is. If
If
it is
they
not
are
that-
entitled for Zirat, then they don't get land compensation. Zirat is for something different issue. And that money is deposited with DRDO. DRDO deposited in Kempa Fund, which state cannot touch. Even
Who is
assuming
representing
they-
Kempa?
and the union has to come. Mr. Kyal was there. Assuming they have a case,
My lord,
that
one
money
thing-
cannot be touched by us.
One thing I point out, sir, which is saying that in Kempa Fund, deforestation amount is to be deposited, not the direct compensation and other amount. Only deforestation amount
No,
is,
see,
I am not claiming deforestation amount.
Whatever
tell us,
amount
you
right here
tell
on the
us.
Kempa Kuching.
I am not claiming deforestation amount. So deforestation amount is with the Kempa.
No.
But I,
No, no.
I am claiming that.
Okay,
our
you want to show
compensation-
us page 86, show us your, what is your determination regarding you?
During deliberation of the.
Which paragraph?
Paragraph 4.
Hmm.
During deliberation of the official DRDO, President informed that out of 190 biga 1 kata 2 lessa, an area of 115 biga 3 kata 16 lessas of land is outside the core area operation of DRDO. On this, Deputy Commissioner Kamrup suggested the DRDO official to explore the feasibility of excluding this area in order to prevent further delay for implementation of their project due to ongoing dispute regarding the land. The matter was discussed and it was suggested that the said disputed land of 115 biga so and so will be returned back by the DRDO to the Forest Department with a request to reimburse the compensatory afforestation amount already
Sir.
charged from DRDO against the said 115 so and so. However, DRDO official informed that the remaining 74 biga 2 kata 6 lessas covering 39 pattadars, we are including in this 39 pattadars, cannot be excluded as it is all within the core area of operation, and hence the decision has to be taken on this matter to resolve the dispute. On
Now,
examination of the report of EO, it appears that out of 74 biga 2 kata 6 lessa, an area of 27 bigas of land was allotted to 27 numbers of families. 1 biga is family under MNP
what
scheme.
is MNP?
It is under the act, one act is there. MNP.
What is that?
I am coming. That
Because that is vital.
Yes.
What is your right?
the balance 47 biga 2 kata 6 lessa recorded land record as the Meadi Patta of and
Now, therefore, you claim that you are in this 47 biga 2 kata 6 lexus recorded land.
yes,
Okay.
I am within this.
You are, according to you, you are within this 47 biga 2 kata 6 lessons.
Yes.
Now, what kind of determination we will make regarding your claim?
That
Tell
has
us
been,
that.
that has been made in my description, kindly see, that has been made.
Now, you claim that your land pertains to this. We'll direct them
Yes.
that if this patta lands are required, they will do it through the proper procedure.
Annexure 1.
In fact, my lord, the petition,
11.
they say they have a patta, old patta, new patta. There should be some land documents to it. Nothing is there.
I have come.
Yes, sir. Tell us which
Annexure 1
annexer?
One.
Of the writ petition.
of the page 11. This document also they have shown submission of statement for payment of ex gratia to grant affected pattadar at Naupaita village to establish DRDO project. With reference to subject matter, I am directed to enclose herewith one copy of statement for amount of rupees so and so only for ex gratia to the affected pattadar of Naupaita village under so and so. That in this regard, I am directed to request to take necessary steps for sanction of the above ex gratia enable to make payment to affected pattadar. Next page is our name statement. In fact, these documents, they have also annexed. They have also admitted, government has admitted that yes, they are the Pattada. My lord, that page is, they have annexed at page 81.
Yes, what is the state of this respondents regarding these two documents and your committee? What is the stand?
Page 81.
Huh?
Page 81. They are affidavit.
How many petitioners are here?
Here, my lord, we are originally 16 repeat not, but out of this 16,
Mm.
legal yards has come.
Mm.
So only 5
Now, all these 16
I-
petitioners' name are reflected in this annexer 2.
annexed to their this certificate.
All these,
All. Page 81.
okay, page 81.
Yeah.
Okay, page 81, tell us.
Page 81, this
Mm.
is the letter written to the chief construction engineer so-and-so, DRDO, for submission of a statement of
Who is
existing
representing DRDO?
and,
KL was there.
Okay, well,
and this statement is given next page, page 7. What? Page.
this is a letter to chief engineer by deputy commissioner.
Yeah.
And what was annexer 1?
Annexer 1,
Same.
same. It is submitted by them also in their affidavit, that I am saying.
No, that is a different
Yeah.
issue. What is their statement regarding this?
Next page.
No, these are the documents we understand. What is their stand as regards your claim that you are a pattadar?
They have not yet.
Where is that?
They have not yet.
Who will decide that you are pattadars? Yes, Talukdar. If they are pattadars according to you. Yes, Cal. If they are pattadars according to you.
We have made payment to the state government, entire payment,
State government to which
the forest department.
That was I was pointing out wrong. Some there's miscalculation and entire money, maybe Air Force, but T20 Campa, we cannot touch it. Even
you make a statement that they are entitled will direct who is Kempa.
that apart from that, they are disputing the title. Because my lord, they say they
Who
are,
are you to dispute their title?
my lord, we say, my lord, when the forest was, the reserve land was there, my lord, in 1971, there was no patata.
But deputy commissioner made a, deputy or revenue authority has made an assertion that they are. Why should we read code go to your stand? You are not the revenue authority. Revenue authority made an assertion that these are the land, these are the patta land, this, that. If you have any grievance, you go to the civil court. Okay.
Revenue says, my lord, the forest, a portion of land is
Ha,
within the forest land.
there was according to the revenue, there was forest land. Those were given say, alternative settlement and some payment. But so far relating to these people, these are pattalets. They have described what are the pattas. If pattalets are there, money is to be paid. There is no acquisition. Okay, they may agree that okay, fine, there is no acquisition. Give us the ex gratia. Give them. Deputy commissioner has determined. Read court. We cannot go to your dispute. If the deputy commissioner would have disputed, we would have said okay, we cannot determine. Deputy commissioner admitted. They pay them the money. They are patta holders.
Well, again, my lord, there is not, that report is also not conclusive, my lord. It says, since the pattas are always, my lord, there was an indication to conduct a joint survey.
No. Come to where is that
affidavit,
minus space? 86.
86,
You come to that.
point number 7, my lord. Finish.
No, point number 7. You
Next.
come to this. The balance 47 bighas, 2 kathas is recorded in land record as the Myadi Patta and 3 bighas as annual patta.
Our contention is that, my lord, if had been there any plan, assuming they are correct, that way back in
Even
71,
they said, when was the notification issued?
it's 1971 notification, my lord. Way back in 71, it is done away with. Now in 2000, only when DRDO acquires the land, they come and say they are patta holder. Whole transaction was between forest and DRDO.
Now, Mr.
DRDO
Talukdar, tell us, what about paragraph 7? Once joint verification by the revenue and forest officer is completed and these pattas are found to be genuine, then the value of land and zirat, if any, may be given to them in the form of ex gratia under Swenso Act with approval from the state government. Any verification done?
Matlab, in our affidavit, the deputy commissioner has said,
Hmm.
second page number 2,
Tell us.
last 2 lines. Further, it is also stated that the petitioner land measuring 33 bighas and so was the requisite, was patta land before it had been declared as reserved forest. So these were patta land prior to.
We want to see what have you done after the recommendation of paragraph 7
Paragraph 7
of page 87. Because as Gogoi has said, he has raised a dispute. Okay, fine, we will ignore his objection if revenue authority asserts his right. But if revenue authority itself says that we are also not aware, we cannot pass a direction. Because it's a writ court and there is no land acquisition process. So how, on what basis you have said that what happened after this? You file an affidavit, we will decide that. If it was a forest land, it was a patta land and it was notified as a forest. Now, issue will be whether they will be entitled for land acquisition compensation. Because for that, we will need to see the notification which whether these lands are included in the forest notification. Yes, Mr. Gogoi, where is the notification 71?
I can bring it.
You bring it.
I can.
Full stop. Hard. This is the present writ petition is filed seeking ex gratia compensation for the land patta land for taking away patta land of the petitioner by the DRDO. Full stop. The case of the petitioner is that in terms of the minutes of they are patta holders and legal years of patta holders of an area of land measuring 47 bighas, 2 kathas and 6 lessas.
33 bigha, 10 less.
33 bigha, 10 lessas.
10 less.
33 bigha, 10 lessas.
Of the 5 patta.
Covered by
Dag number 33, KP patta number 71.
Dag number 33, KP patta number
71.
71.
Dag number 32, KP patta number 26.
Uh,
Dag number 31, KP patta number 70. Dag number 29, KP patta number 72. Dag number 30, KP patta number 31.
Okay, 31. Huh? Just give a note. Huh? Give a written thing. Other it will be a Equation.
By area of land measuring
33 bighas. 33 bighas. Okay, okay, covered by Dannapas fences. And said land has been taken for construction of some project by DRDO. Referring to the minutes of meeting for acquisition of land held on 8/5/2014 in the conference hall of Deputy Commissioner Kamrup Amingao, the learned counsel for the petitioner submits that at paragraph 5 of the said minutes, it has been recorded that the petitioners are Miadi Patta holder of the said land. Full stop. Referring to the Annexure 1 communication dated 21/3/2017, the learned counsel further submits that the deputy commissioner has already requested the DRDO to release the amount in favor of the petitioners. Full stop. Mr. S.C. Kyle, learned counsel representing DRDO, has submitted that the entire amount has been deposited in the account of the Forest Department, Government of Assam, as the Forest Department made a claim that land is under reserve forest. Full stop. Reserve forest. Mr. Gogoi, learned standing counsel for the Forest Department, referring to the minutes, paragraph 7 of the minutes dated 8/5/2014, contains that though the petitioner has made a claim of title over the land in question, however, admittedly, such patta was issued in the year 1964 and the land in question were brought under the reserve forest by a notification issued under Assam Forest Regulation in the year 1971. Therefore, subsequent to such issuance of notification, the petitioner shall have no right for claiming any compensation, including what you call ex gratia compensation. Full stop. The minutes also reveals that whether the land belongs to the Forest Department or it's a reserve forest or the petitioner are entitled for compensation needs a verification. Full stop. However, the affidavit filed by the Deputy Commissioner is silent whether such verification has been done, and if done, what is the determination thereof. Full stop. The Forest Department has though claimed that notification under forest regulation under Assam Forest Regulation was issued. However, no such notification is annexed with their affidavit so as to suggest that land of the petitioner, patta land of the petitioner, was also brought under such notification. Full stop. In the aforesaid backdrop, the learned counsel for the in the aforesaid backdrop, Mr. Talukdar, learned senior counsel representing the Deputy Commissioner, submits that he may be granted to obtain instruction as regards the determination of the Revenue Authority in this regard. More particularly, to obtain an instruction whether the petitioners were patta holders and whether they are entitled in the opinion of the Revenue Authority for compensation. Mr. Gogoi also seeks some time to produce the notification issued under the Assam Forest Regulation 1891 to show that actually land was forest land.
petitioner.
Petitioner's land were notified as forest land. Full stop. In the accordingly, matter stands adjourned and be listed. When? Tell us, you tell us. They are waiting for so many years. Wait for 2-3 more weeks, no problem on that, but you asserted. 2 weeks, 3 weeks. 3 weeks, let's give a date. 23rd of April.
Much.
Please over.